Yes. Mr. Friston, would you like to continue?
My Lords, yes, thank you. May I just clarify one or two points concerning the legislative chronology, this is rising out of the points made by Lord Justice Davis this morning. The 1986 regulations and the 1985 Act came into force on the 1st of October 1st October 1986. And the relevant sections of the Drug Trafficking Offences Act 1986, along with the rules of the Supreme Court Order 115, that being the first legislative scheme that allowed for this sort of enforcement, came into force on the 12th of January 1987. Just having made those points, I now continue with ground 2. If I could ask the Court please to turn to page 17 of the Authorities Bundle.
Thank you.
You will find here section 17 of the 1985 Act, and so paragraph 1 reads, subject to the below, and then skipping a few lines, the Court may order payment out of central funds of such amount as the Court considers reasonably sufficient to compensate the prosecutor for any expenses properly incurred by him in the proceedings. And in my respectful submission, that word expenses is used in exactly the same way that it is used when talking about the expenses of a litigation friend or the expenses of a trustee, and as such will include anything, any expenses subject to any rule or provision that said otherwise. Of course, they must be properly incurred and they must be reasonable, but it may include anything. That fits in very well with the scheme that funds prosecutors generally, because it is in the public interest that people prosecute cases where appropriate. So it is.
What are we to make of the fact that section is headed prosecution costs?
Well, the heading to any litigation is only a weak aid to interpretation, but certainly it points towards costs. So it would be difficult, for example, for a prosecutor to claim something which is patently not costs. It's difficult to think of an example, but the point I make is that expenses includes costs generally, and not simply costs that are the costs of the prosecutor himself or herself purchasing legal services. And one reaches the same conclusion if one turns to the regulations. In that regard, if I could ask the Court to turn to page 143 of the bundle, which I think is tab 6. Now, these regulations, they are lengthy, but many of the points that are made in these regulations relate to specific items of costs, so certainly about travelling expenses and that sort of thing, which is very commonplace in a criminal setting. But the relevant part is regulation 7.1, which reads: the appropriate authority shall consider the claim and any further particulars, information, or documents submitted by the applicant under Regulation 61 shall allow costs in respect of any of such work as appears to have been actually and reasonably done, and such disbursements as appear to have been actually and reasonably incurred. So there is a mechanism there for assessing costs. It doesn't matter whether those costs were incurred as a result of the prosecutor personally purchasing legal services, or whether they are costs that he or she has to pay as a result of being ordered to pay costs. They're still costs, and there's a mechanism there for those costs to be determined. and there is nothing explicit or express that says otherwise in the regulations or in the 1985 Act. So I say that this situation is directly analogous to trustees and litigants and litigation friends in the sense that expenses will mean expenses. It will include adverse costs. There's another reason as well why this is what one would expect, and this arises out of the points that were made earlier on about parity. This is also the mechanism by which any innocent third party who may be awarded costs will also be able to have the comfort of knowing that they ultimately will be able to recover those costs from central funds, because costs will follow the event in the proceedings under RSC 115. If costs are awarded, and costs are awarded against the prosecutor, and then they can be recovered from central funds. And in my respectful submission, that is what one would expect. The prosecutor is acting not as a private prosecutor, they're acting as a prosecutor. And if somebody is wrongly brought into effectively criminal proceedings and is awarded costs, it is only right that the state should bear those costs. And as I say,
the argument doesn't quite hold up, does it? Because take the case of a third party who is really very, very unreasonably brought into the proceedings. Yes. by the prosecutor. Then you will not have security for central funds because the costs will not have been reasonably and properly incurred.
Well, that would be a matter for discretion of which would be a matter of discretion as to whether or not the court were to make an award of costs in those circumstances. And in any event, one would hope that those circumstances would be rare, if not fleetingly rare. But in the vast majority of cases, prosecutors will act as ministers of justice. They will act reasonably, and they will act in such a way as to engage these provisions in their ordinary way. By which I mean an award would be made. So those are my points on ground 2. I note that at paragraph 43 of the skeleton argument, my learned friend makes a number of points regarding discretion. I'm not entirely sure whether those are made in respect of ground 2 or in respect of the appeal generally, but I do respectfully remind the court that this is a point of principle. Our appeal is in respect of an order to set aside an order that had already awarded us the prosecutor costs out of central funds, including Ms. Kiwana's costs. So this appeal is in respect only of that point of principle. And to do that, I do propose to address the court on the issue of discretion. So, my lords, unless the court has any questions, those conclude my submissions.
No, thank you very much, Mr. Friston. Mr. Kerr.
I'm grateful, my lord. My lord, my lady, the overarching submission that I make is that Section 17, properly understood, is restricted to criminal proceedings, and that it is fundamentally wedded to the extent of Section 6 of the Prosecution of Offences Act, such that the two, in a sense, rise and fall together. So that if a prosecutor is relying on a different source of jurisdictional power, other than that of Section 6, then Section 17 has no bite. Before I go into my substantive submissions, I will, if I may, just make 5 short rebuttal points, the intention of which is insofar as it's of assistance to clarify what I think might be misapprehensions in respect of isolated issues arising from my learned friend's submissions. The first of which is the Lord's decision of Steele 4. So in that regard, I'm going to ask my Lord and my Lady to turn to tab 11 of the Authorities bundle. And having done so, simply to turn over to page 228, that's in bundle pagination as opposed to the authority pagination. And under...
I'm so sorry. Actually, what is the page you're giving?
It's behind tab 11.
No, I've got
it's 228 of the authorities bundle.
Right.
Numbering bottom right. I'm grateful, my lord. What you will see looking at this head note is by the italicised words held, that the House of Lords was dealing with three issues. The first was whether Section 51, and Section 51 is commonly used and deployed in these circumstances for non-party costs orders, which effectively says in terms that the court has got unfettered discretion to determine by whom an order for costs is paid. What one sees under the 10 lines under held is that the House of Lords is grappling with two arguments. The first is whether Section 51 grants an express power, and the second is whether, if it does not, can one imply a power. And the reason why I make that point is that when, as I'm going to come to now, we look at Lord Bridges' comments about a clear and express direction, that is made not just in the context of propositions put forward based on implication, but also propositions put forward based on express jurisdiction. If I might ask you all to turn to page 234. 234F, you will see section 51, as was then and it is today in similar terms. This was the express power that the Civil Division of the Court of Appeal identified as giving it the ability to make orders for costs to be paid out of central funds. And it's particularly the words after the three dots in that excerpt, shall be an expression of the court, and the court shall have full power to determine by whom and to what extent costs are paid. Moving forward to page 237, we see at number E that in addition to that principal argument, two alternative grounds were made, one of which was based on implication. And we can see the implication argument appears at H, the bottom three lines. If you then be so kind as to turn to page 238. At page 238, from E to G, Lord Bridge sets out the exercise that he undertakes in answering whether Section 51, giving that untrammelled costs power, is such as to include costs out of central funds. And we can see from 5 lines by E, the Constitutional Convention jealously safeguards the exclusive control exercised by Parliament of both the levying and expenditure of public revenue. It is strike law that nothing less than clear, express, and unambiguous language is effective to levy a tax. Scarcely less stringent is the requirement of clear statutory authority for public expenditure. Significantly, then, at letter G, Lord Bridge goes on to state, before considering whether, in spite of these apparent difficulties, an unexpressed power toward payment of costs of money provided by Parliament can properly be implied in any of the sections of context, it is necessary and tedious to consider in some detail the nature, context, and provenance of the legislative provisions in which the jurisdiction is specifically conferred toward payment on account of costs from central funds. So the exercise that Lord Bridge then undertakes from G over the succeeding pages is to undertake an exhaustive analysis of all of the legislation that enables costs to be paid out of central funds. At this point, Lord Bridge is going beyond the narrow confines of Section 51 and undertaking a detailed historical expose of all of the provisions which enable costs to be paid out of central funds. And at the top of page 241, at paragraph A, the chronology will move forward to the Prosecution of Offences Act 1985. We see this at the top of the page 241 by A. Now at B to C, section 17 is set out in full.
Sorry, I personally find it much easier if you have the page of the authority, but if you want to use the ones at the bottom, which page are you using? 200 and...
My lord, I'll go to the page of the authority. Forgive me, I was just following on.
No, I know, but I mean, the others may differ, but since this doesn't have paragraph numbers, if I'm making a note in my book, I would be referring to the page number of the authority.
Of course, my lord, it's page 36 then.
Thank you.
I'm grateful. And at 36A, we see the introduction to the 1985 Act. At 36B and C, section 17 is set out word for word.
Yes.
Section 36C to G, section 16 is set out in full. Section 16 deals with when the defendant can recover costs from central funds. 36H deals with the 1986 regulations. And over the page at 37, at 37A and B, we get the House of Lords' conclusion, having gone through all of the legislation that gives the right to recover costs from central funds, that the jurisdiction has been conferred on the criminal division of the Court of Appeal only. That's A and B.
I mean, I see what's said there, but there's no analysis by reference to section 17 of the point we're considering here.
With respect, my lady, I differ. What Lord Bridge has done, has undertaken the exercise of a historical expose to answer the question of whether the civil division has got jurisdiction per se, rather than simply within the confines of section 51. Now, I will go on to other passages.
It's answering the question whether one can read the jurisdiction conferred in the precise question which you've earlier identified, whether you can read the jurisdiction conferred by section 751 as including one in which a costs order can be made out of central funds.
My lady, I fully accept that was the point before the House of Lords, but when one bears in mind that the exercise Lord Bridge was undertaking was to answer the question of jurisdiction per se, and then looks at paragraphs A and B on page 37, which again, the conclusion therein, and of course I accept, my lady, the question is set by the confines of section 51. The answer that he's given suggests that Lord Bridge, having looked at all of the legislation that gives rise to the power to order costs out of central fund, deviates slightly beyond the question into the wider question of whether in fact the civil division of the Court of Appeal has got the jurisdiction per se, rather than simply dovetailing from section 51. Now, of course, I accept, my lady, that the question that is put determines the answer that he's given, but the answer that he's given here is just as much a function of a historical exercise which has gone through 4 editions of statute dating back from the late 19th century to Lord Bridge's conclusion of A and B, which is to the effect that not section 51, or rather the conclusion is not that section 51 doesn't give jurisdiction, it's actually that the jurisdiction rests in the criminal division of the Court of Appeal rather than the civil. What I will say is that irrespective of that point, the next two passages go on to support the proposition which at points my learned friend accepted and then resiled from, that even if the court is not with me in the sense that the historical expose is illustrative of Lord Bridge concluding that no jurisdiction exists per se, rather than no jurisdiction exists as a consequence of section 51, he does say in no uncertain terms that when one is looking at the exercise as to whether costs can be paid out of central funds, one needs to see clear and express intimation of such a thing. The next passage in this authority I'd like to direct your lordships and ladyship to is at 38H. 38H. It may be debatable whether these proceedings were civil or criminal, but in either case I can see no possible basis for an award of costs out of central funds. The power of the divisional court in criminal proceedings under sections 16 and 17 of the Act of 1995 is clearly limited to awarding costs to the defendant or the prosecutor, and as I hope I have already shown, there is certainly no power to award such costs in civil proceedings. Again, much the same point. And the next material part of this authority is the more general comments that one sees at page 40 at D to G. And I'm simply going to ask your lordship's ladyship to read D to G, but with a particular emphasis on E to G. And then the final section is simply at 41B D. And at 41B to D, we see the illuminating words clear express terms. Particularly the sentence, I find it difficult to visualise any statutory context in which such a jurisdiction could be conferred by anything less than clear express terms. And my lords, my lady, that's why it was that my learned friend initially acceded to the proposal that actually the question that this court needs to be asking itself is whether section 17 in clear and express terms, provides that civil enforcement proceedings are such that costs can be recovered out of central funds. That is ultimately the lens through which this question is to be addressed. The next short rebuttal point I'd like to make is the proposition that my learned friend put, that section 17 is such that it can have effect in civil jurisdictions, is inconsistent with what the House of Lords said in Re Norris, which is behind tab 13. In Re Norris itself, the subject act was the Drug Trafficking Offences Act 1986, but both my learned friend and I, as well as the court below, are at one in addressing those two acts as, to all intents and purposes, conferring similar powers, albeit in respect of different proceedings. But if the court would be kind enough to turn to page 1400, read next to paragraph C, D, and E. and again, particularly it's that reference to a clear and express provision in a statute, for a court to conclude that there could possibly be any form of cross-pollination between the statute that's proper place is that within criminal proceedings and other proceedings which themselves are civil proceedings.
I'm sorry, I don't have that. I've got 1,400 C to E, is that right?
Indeed, and if one starts at C, it says the English system of criminal justice does not itself confer any civil jurisdiction upon the
Oh, I see, I've got you. Thank you.
provision of statute to achieve that result.
Yeah, I see.
Now,
Thank you.
of course, this is entirely consistent with what it is that Lord Bridge has said. Lord Bridge is saying you need clear and express words to conclude that there is a power to order costs out of central funds, and what one sees here from Lord Hobhouse is you equally need clear and express provision to come to the conclusion that a statute whose proper place is within the criminal jurisdiction could cross-pollinate or have effect in the civil jurisdiction.
Mr. Cohen, could I ask you please, on that basis, what is your stance with regard to enforcement proceedings under POCA 2002, which assign such matters to the Crown Court? What's your position on that?
You're absolutely right, Michael. The reason why I opened by saying that Section 17 is wedded to Section 6 is because when we are in POCA territory and we are asking for a receiver to be appointed over defendant's assets, or one is trying to institute tainted gift proceedings, the jurisdiction, or rather the ability of the prosecutor to do so, arises from Section 50 of POCA. It does not rise from Section 6.
But is then your position that in enforcement proceedings under POCA, a private prosecutor's costs may be recoverable?
It is not. In enforcement proceedings under POCA, because, in my submission, Section 17 of the Prosecution of Offences Act is wedded to Section 6. Section 6 gives the private prosecutor the standing to commence criminal proceedings. And because Section 6, and in my submission Section 17, are to rise and fall together, where enforcement proceedings are undertaken under a POCA regime, one looks at Section 50 of POCA for the right of the private prosecutor to bring it, rather than looking to Section 6.
I understand that, but I just want to be clear that if you have a private prosecutor, perhaps any prosecutor, who enforces under the provisions of Section 50 onwards of POCA, are then, in principle, costs capable of being recovered out of central funds?
They aren't, because you have to look to Section 50.
They are not. They are not.
The reason being, sorry, my lord, I haven't been clear. The reason why they are not recoverable is because the prosecutor's standing to bring the receivership proceedings arises not from Section 6 of the Prosecution of Offences Act, but from a different statute. Now, under the Criminal Justice Act, that's Section 50, and under POCA, under the Criminal Justice Act, that's Section 88, and under POCA, that is Section 50. It does not derive from Section 6 of the Prosecution of Offences Act.
So, I'm so sorry, I'm still not quite following. Are you saying then that a prosecutor cannot in any circumstances under the POCA regime get costs out of central funds?
Yes, my lord, insofar as the relief the private prosecutor is seeking is receivership and gift proceedings. Because
that must be a private prosecutor.
Well, for the simple reason that Section 17 says that no public authority, which includes CPFs, can possibly recover costs. So it's only private prosecutors that can recover under Section 17.
So I'm so sorry to press you, but your argument then is in fundamental outcome the same, whether or not it's a CJA 1988 case or whether it's a POCA 2002 case.
Exactly, my lord. That's absolutely right. And there's a reason why. My lord, when POCA was instituted, so was a new criminal procedure law, and perhaps this would be a convenient moment to go to it.
Well, I don't know how important this point is you've just been discussing with Lord Justice Davis. I mean, he is much more of an expert in this field than certainly I am. It sounds as though that discussion where you ended up saying the position is the same for a private prosecutor or prosecutor in relation to being recompensed out of central funds for enforcement proceedings is the same, and you can't recover from central funds under either. It sounds like an important point. Now, all I want to say is, should I look at Section 50? Is that important for me to understand that point?
The short answer is, my lord, the issue before this court does not touch upon POCA, but equally, if the court would like to go there, I'm very happy to address it.
But I think I'd just like to understand the point you're making, in case it is an important point.
My lord, the point that I make is that there is no difference in terms of the scope of the ability of the private prosecutor to recover from central funds, whether we are under the CJA or under POCA.
And I would like to look at Section 50 to understand the point.
I'm grateful. If the court would be kind enough to turn to tab 4.
I assume then there's no authority on this point under POCA.
There's no authority under POCA, nor is there a single case under the CJA where Section 17 has been deployed successfully to recover costs out of central funds and enforcement proceedings.
Thank you. Thank you.
At page, it's top right at page 75, so it's only 4 pages in. Sorry, forgive me, perhaps
Thank you.
a dozen,
Yes.
so no more than 10.
Yes, and I've got that.
One sees Section 50,
Yes.
and Section 50 is in materially the same terms as Section 88 of the Criminal Justice Act. And what is important is that, just as under the Criminal Justice Act, the prosecutor's power to commence enforcement proceedings arises not from Section 6 of the Prosecution of Offences Act, but from Section 80. That point is mirrored in Section 50 of POCA. In other words, it is this particular provision which gives rise to enforcement proceedings, rather than any self-standing, pre-existing ability arising from Section 6 of the Prosecution of Offences Act, which is the statute which enables the prosecutor to prosecute up to the stage of the confiscation.
So sorry, Mr. Cohen, I don't want to press too hard on this point, and I'll probably ask one more question and I'll shut up on it. But I just want to be clear. Are you saying that enforcement proceedings under the POCA regime, are they civil proceedings or criminal proceedings?
Section 17 itself is obviously...
Could you just answer the question, please? Are they civil or criminal?
They are proceedings which take place in the Crown Court addressing...
Are they civil or criminal proceedings?
My lord, fundamentally, it depends on whether criminal proceedings is going to be determined by the court under which the actions take place, in which case it is yes, or it is the subject matter of that which one is determining, in which case the answer is no.
Well, in that case, that rather undermines your cross-pollination point based on Norris.
The reason why it doesn't in my submission is that whilst I fully accept that enforcement proceedings under POCA take place in the Crown Court, my fundamental position is because Section 17 is wedded to Section 6, one is looking at a different jurisdictional source to identify the power that the private prosecutor has to engage in enforcement proceedings. And indeed, to make that point good, and I don't want the tribunal, in a sense, to get too engaged in asking oneself the question as to whether it is criminal proceedings or civil proceedings, because Section 17 itself doesn't use those words. It uses the terms, of course, that we're all familiar with, which is in respect of an indictable offence, and that is the prism through which we are seeing this. But of course, the POCA regime was instituted at the same time as a new set of criminal procedural rules, which are behind tab 9. And it is instructive, if I could ask the court to turn to tab 9. And I'm going to refer to the internal authorities pagination, that at page 196, and forgive me, I'll go on to explain in more detail what it is that I'm taking the court to. These are criminal procedural rules that were brought in with they deal with confiscation and related proceedings, and one can see that Rule 33.2, the paragraphs beneath, restraint and receivership proceedings. And Rule 33.47 deals with orders for costs in restraint and receivership proceedings. And over the page at 198.
So, sorry, this is under, you've got restraint and receivership proceedings rules apply generally, and then you've got your order for costs. Is that the one you're talking about?
Exactly that, and that's just over the page, my lord.
Yeah, I've got that.
And if you'd be so kind as to go over the page and look at orders for costs at 33.47. And again, this was a new criminal practice direction brought in given POCA. 33.47 is the mirror of CPR 44.
So, just pausing there, the uninitiated, there's no provision either in POCA itself or in the criminal procedure rules brought in at the same time, which expressly refer to a right to recover costs out of central funds. Is that right?
Correct, my lord. We find the right to recover costs out of central funds appears in an entirely separate practice direction which pre-existed POCA. And that, if I can be so bold as to ask you, appears at page 206. And forgive me, again, I'm referring to the authorities' page numbers because these are excerpts.
So, well, I'm just making a note on the last point. Just wait one moment. Right. So the point is this. You don't have to ask yourself, as you did under the 1985 Act, is this right? No, sorry, you don't have to ask yourself, as you did under the either the 1985 Act or the 1988 Act, whether or not the proceedings are criminal proceedings. I'm using that as generic words. I know the words we're looking at is related to an indictable offence, but you don't have to ask any of those questions in order to see whether you can get payment out of central funds when you get to POCA, because POCA itself doesn't refer to that language or central funds, and the position as to costs is just dealt with expressly in 33.47.
Yes, my lord. That is exactly the position. One has a direct equivalence because POCA is allied with a practice direction which mirrors the civil procedure rules under Part 44.
So your I just want to, I'm not saying you're right or wrong about this, I'm just trying to understand the analysis. So your position is it's a misguided question to ask whether or not enforcement proceedings under POCA are criminal or not, because the point simply doesn't arise, because those are questions which may be relevant to the 1988 Act, but they have no relevance to the statutory or regulatory regime under POCA. Have I understood that to be your position?
Yes, my lord, although I do say that the analysis which is such as to require the conclusion that Section 17 does not apply under the 1988 Act is the same for POCA, because we're focusing on the words in respect of an indictable offence. And when one is taking enforcement proceedings pursuant to a statutory fine, that is not in respect of an indictable offence.
Right.
So the analysis dovetails. If we're thinking of section, and it might be instructive, I do have some substantive points, but I might, if I may, perhaps go back to first basis so I can lay the propositions which I subsequently go on to make so far as POCA is concerned. Because part of, and indeed one of the overriding considerations so far as section 17 is concerned, is that, and if you'd be so kind as to turn to tab 2,
Yes.
and to go back to prosecution costs. And again, we're looking again at section 17.
Yes.
17(1)(a) says in any proceedings in respect of an indictable offence. What it doesn't say is in any proceedings in respect of the indictable offence. So simply the question is, when you are looking at enforcement proceedings, whether under the 1988 Act, which we are concerned with, or whether under POCA, for those receivership proceedings in respect of an indictable offence, what the language does is sever the indictable offence from the enforcement proceedings because it uses an rather than the. And I'm going to go on to explain the case of Taylor, which provides that when you are looking at enforcement proceedings, they are simply recovering funds in respect of a fine, and those are not indictable. That's not an indictable offence. And that, again, places reliance on the word "and" there rather than the.
Sorry, Mr. Cohen, it's not a fine, is it? Confiscation is not a fine.
Well, section 75 of the Criminal Justice Act, it's behind tab 3, and the court has yet to have been taken to this. This is behind tab 3. Internal pagination 18, so by that I mean tab 3, pagination 18. Please ignore the bundle pagination.
Yes.
And section 75 provides that where the Crown Court orders the defendant to pay money pursuant to a confiscation order, the powers of the Crown Court in respecting to fines and enforcements shall have effect as if that amount were a fine imposed on him by the Crown Court.
Yes.
And equally, if you'd be so kind as to turn to...
I mean, it is a fine.
Well, tab 22.
It gives you the same equivalent powers as you would have in respect of a fine.
I quite agree, my lady. The proposition is made good behind tab 22,
Right.
which is a recent Supreme Court decision of R and Hilton. In paragraph 19, and if I could just ask you to read paragraphs 19 and 26. And again, paragraph 26, notwithstanding POCA, still holds the distinction between the criminal and the civil law. My lords, my lady, this passes the analysis is that if one accepts that the confiscation order is simply payment of a sum of money and then reverts back, which is what is set out in paragraph 26, so the proposition is that because a confiscation order is simply an order for the payment of a sum of money, if one goes back to the words of section 17 and asks oneself, are proceedings for the enforcement of a sum of money in respect of an indictable offence, the answer is no, because what one is dealing with is an order to pay sums rather than the indictable offence that gave rise to that order. And again, Taylor and Westminster behind tab 16 makes that distinction. This was a decision of Lord Justice Pill and Mr. Justice Cranston, sitting as a divisional court. And in this decision, the question was not whether they were criminal proceedings per se. And if I can just ask you to turn to paragraph 10. In paragraph 10, the court was addressing Criminal Defence Regulations 2001. And it entered paragraph 12.1 under paragraph 10. It says representation for the purpose of proceedings before a magistrate's court may only include representation by an advocate in the case of A, any indictable offence, including an offence which is triable either way. So the words there are in the case of any indictable offence. We're dealing with in respect of. So the word respect takes the place of the word case. That is simply the distinction between the two. And at paragraph 25, I'm just going to ask the court to read the final 4 lines in paragraph 25. And having done so, to then read paragraph 26, which again deals with the case of Lloyd and Vaux, which we've seen referred to a number of times. And in the middle of 26, it provides that Regulation 12 has no application as a matter of statutory interpretation because such proceedings are not in the case of an indictable offence, rather they are in a statutory context quite separate proceedings. The enforcement of the confiscation order is to be treated as the enforcement of a fine. And the reason why that point is made is going back to section 17. We are simply asking whether the enforcement proceedings are proceedings in respect of an indictable offence. We are not asking whether they are in respect of the indictable offence. We are not asking if they are as a result of an indictable offence. We are simply looking at the enforcement proceedings and identifying whether they themselves, so the proceedings, in these circumstances, the application is made to have the appointment of a receiver over the defendant's assets and for various transactions that have taken place after the commission of the offence to be deemed to be gifts within the purview of the 1988 Act. That is the extent, in a sense, of what it was that civil courts were asked to do. That was Part 8 claim form. It numbered as the defendant and all the third parties who were held to have, or alleged to have been in receipt of gifts, and sought a receiver over the defendant's assets, and then declarations that third parties have been in receipt of gifts from the defendant after the commission of the offence. And I do reiterate that those gifts...
Sorry to interrupt, Mr. Cohen, but do you accept confiscation proceedings themselves are in respect of an indictable offence?
Confiscation proceedings are part of sentencing. So yes, if I can take you to really Zinger, then
And indeed, on any view, they are criminal proceedings because they are part of the sentencing process.
exactly right.
What is the purposive sense in saying a prosecutor can get his costs of the confiscation proceedings out of central funds in an appropriate case? But then, when in order to give teeth to the confiscation he gets, he tries to enforce, he no longer can. what's the central purpose in that?
Well, part and parcel of that goes back to a question that my Lord the Master of the Rolls, which goes to when one is dealing with enforcement proceedings, what one is addressing is the receivership which obviously deprives the defendant of assets, and the gift proceedings, which themselves don't need to stem from the commission of the wrong, but deprive third parties of gifts. Now, those proceedings, notwithstanding what my learned friend said, and he mentioned a number of times, the enforcement proceedings inure for the benefit of the Crown. That is simply not the case. The enforcement proceedings inure solely for the benefit of the prosecutor, and we can see that in Section 88 of the Criminal Justice Act, which is the waterfall provision that, Section 81 of the Criminal Justice Act, which is the waterfall provision. And I will just touch upon that if I may. In other words, we have deviated really away from the core purpose of the private prosecution towards what is ultimately a form of redress which benefits only the prosecutor. And again, we can see that from Section 81 of the Criminal Justice Act behind tab 3.
81 or 88?
Forgive me, it's tab 3 and it's Section 81. I misspoke earlier. It's page 28 on the internal pagination.
Thank you.
Sorry, Mr. Cohen, which tab was it? Sorry.
Forgive me, tab 3, my lord.
Thank you very much. Thank you. Thank you.
Now, just to make sure I understand all this, because you're making a lot of points here, on this, I just want to make sure I understand the relevance of tab 16, which was it's not binding on this authority because it's a divisional court decision, but you're making a direct comparison, is this right, between Regulation 12 and the words "in the case of" an indictable offence, and you're saying that that's not materially different from the wording in Section 17 in respect of. That's one part of it.
Exactly that, my lord.
And then you're saying that the analysis, which obviously you adopt in this divisional court case, as I understand it, because I haven't read it all through, but the bits you showed us, are that those words, in the case of, are not sufficient to embrace confiscation enforcement proceedings, because those are, as I understand it, this is a rather sophisticated argument, because that they are equivalent to the enforcement of a fine through a magistrate's court, and that isn't an indictable offence. So you're kind of using the analogy of saying, well, it doesn't. I don't think the fact that they treat it as a fine is the point. The point is that it's treated in a separate way. The court says it's treated in a separate way from the obtaining of the order. I think the finding is a bit of a sophistication.
I agree, my lord. At its very core, it is providing and it is relevant that the basis upon which that court came to the conclusion that because it was to be enforced as a fine, it was not in respect of an indictable offence, was based on Section 6 of the 1984 Act, which is behind tab 7 and is word for word the same as Section 75 of the CJA. So both the Drug Traffickers Act and the Criminal Justice Act provide that when you are dealing with a confiscation order by way of enforcement, one is to have the powers, and the court is to approach it as if it were a fine, which is reflective of the fact that the confiscation order provides for a statutory debt payable by the defendant wrongdoer.
I see. So you say the analysis in the City of Westminster case, Taylor and City of Westminster, you say you can transpose that directly to a case under the 1988 Act, with the substituting for the words "in the case of" with "in respect of."
Exactly, my lord. Paragraph 12 of the City and Westminster case provides that it was dealing with and directly addressing Section 6 of the Drug Trafficking Offences Act 1986, which should be behind tab 27 of the authorities handbook. Forgive me for continually jumping around.
I just want to make sure I understand the argument. That's the most important thing.
I quite understand, Lord. I'm grateful for the opportunity. Behind tab 16, back at the City of London Westminster case, and I perhaps should have gone to this greater depth. Tab 16, City of Westminster, paragraph 12, the issue that the court was addressing was the Drug Trafficking Offences Act 1986. It says, Section 1 of that legislation enables persons sentenced in relation to drug trafficking to be subject to confiscation. Under Section 6 of that Act, Parliament provided that where the Crown Court ordered a confiscation payment, any amount would have effect as if it were a fine imposed by the defendant by the Crown Court. That's paragraph 12. And if you'd be so kind as to keep a finger in that paragraph and turn to tab 27. Tab 27 is Section 6.
Tab 27, I don't know if I've got a tab 26.
It may well be. It was delivered late, and there was.
Oh, I see. This is a separate Drug Trafficking Offences Act. Yeah, I've got it separate. Yeah, I've got it. Yes.
And if you'd be so kind to turn just over leaf, you will see Section 6, which says, where the Crown Court orders the defendant to pay any amount under Section 1 of this Act, in other words, a confiscation order, it says the powers of the Crown Court in relation to fines enforcement of the Crown Court shall have effect as if that were amount were a fine imposed on him by the Crown Court, which is exactly the same wording that appears at Section 75 of the Criminal Justice Act, which I took the court to, and my lady quite properly pointed out that in many ways that was dealing with the enforcement of the fine, but it doesn't in and of itself render it simply a fine. But I hope the case of Wee Hilton makes good the proposition that a confiscation order was a statutory debt. So if one accepts that it's a statutory debt, one accepts the parallel between Section 6 of the Drug Trafficking Offences Act, which is word for word the same as Section 75 of the Criminal Justice Act, then the analysis that appears in City of Westminster is directly on point.
Understand, thank you.
My Lord, I'm grateful. I'm sorry that I didn't go into the detail I should have done perhaps in the first time that I addressed the point.
But this part of your analysis has nothing whatever to do with the distinction which we see in the cases between civil jurisdiction for enforcement and criminal jurisdiction up to the date of the order. This is a completely separate way of looking at the case.
You're absolutely right, my Lord. Paragraph 42 of my skeleton. What I say in paragraph 42 is, if enforcement proceedings could be understood as criminal proceedings, whatever the position, Taylor and Westminster provides that because one is asking oneself whether the proceedings in question are in respect of an indictable offence, where one is dealing with simply recovering sums to satisfy a statutory debt, that is not to be understood as in respect of an indictable offence. Because recovering sums for a statutory debt, appointing a receiver, instituting gift proceedings against third parties are not indictable offences. And the fact that Section 17 says in respect of an indictable offence as opposed to in respect of the indictable offence means that whatever the position on the criminal civil proceedings juncture, we are still asking oneself whether the enforcement proceedings are in respect of an indictable offence. And again,
Thank you.
my Lord, I'm grateful.
Mr. Cohen, at some point, could you address the terms of the order that was made in this case?
Of course. My lady, if you wouldn't mind.
Yes, of course, but which contemplates, not now, but in time that's convenient, which contemplates, as it were, the criminal purview being maintained in respect of what happens to the subs realised.
I will, and indeed, my lady, I'm going to answer that, if I may, by reference to the Criminal Justice Act under tab 3 itself. Section 18 of the Criminal Justice Act behind tab 3.
Are you going on to a new point now?
No, this is answering my lady's point, but at the same time, I'm going to deal with the waterfall point. In other words, my learned friend's proposition that the prosecutor is acting for the benefit of the state, which I say isn't correct. But what my lady has dealt with is the fact that the order envisages that one might go back to the Crown Court in certain circumstances. And what one sees at section 80 behind tab 3, this is page 27 of the statute. Is at section 81A, and section 80 is the point at which a receiver can be appointed. Section 81A provides that where a confiscation is made in proceedings instituted for offence which is part of the Act of Crimes, and the proceedings in question have not, or the application in question has not been concluded. So you can only make an application for the appointment of a receiver if the proceedings have not been concluded, those of course being the criminal proceedings. And the definition is itself provided at internal pagination 59. Pagination 59, and look at the bottom of 59, it says proceedings for an offence are concluded. D. If a confiscation order is made against him in those proceedings when the order is satisfied.
Sorry, I haven't got that. Which section are you talking about?
The same section of the Criminal Justice Act with tab 3, and it's page 59 at the top right, or rather the pagination at the top of the pages.
Right. Sorry, I was looking at section 80.
Indeed. And what section 80 says is you can only make an application for a receiver
No, I've got that.
in circumstances where the proceedings have not been concluded.
Yes.
And it would be so kind, my Lord, just to keep a thumb in that paragraph,
Yeah.
and then to turn to page 59, and at the bottom it says proceedings for an offence are concluded, and then over the page D, if a confiscation order is made against him in those proceedings when the order is satisfied.
I'm so sorry, it's entirely my fault, Mr. Kane. I've got page 59 of 552.
Forgive me, I was trying to refer to the tab pagination and giving you early indication, but if we could go then to page 80.
Right, no, that's fine, as long as you say it's the pagination at the top, my fault. Right, now I've got you. And I've got you at the bottom, yes, I see it now, thank you.
And if you go over the page, you'll see D provides that if a confiscation is made against him in those proceedings when the order is satisfied.
So I've got that, thank you.
So what that means is those proceedings for the purposes of section 80 continue until the confiscation order is satisfied. Now that being so, what we are asking ourselves is whether enforcement proceedings, if we're seeing this through the proceedings lens, are a separate set of proceedings. You know, you've got the criminal proceedings, which are in the Crown Court, which are ongoing. And of course, my Lord Master of Rolls made the very good point in the case of Lloyd, that where you are going back to the Crown Court to get a warrant for committal to prison, that those dealt with criminal enforcement. Whereas in the case of Lloyd, a distinction was drawn between criminal enforcement and civil enforcement. And really, rather than populating the discussion with criminal proceedings and civil proceedings, I submit, I think probably be a greater benefit to discuss it in terms of criminal enforcement, which is when you go back to the Crown Court to get a warrant for the defendant to be placed in custody, and civil enforcement, which is what the government of the United States in Montgomery goes to pains to say, does not fall within the purview of criminal proceedings. So if one sees it on that basis, rather than identifying the nature of the proceedings, but rather distinguishing between criminal and civil enforcement, then the tangent I draw between the CJA 1988 and that of POCA, and again, the fact that POCA has got its own costs rules, means that my Lord Justice Davies' point as to whether POCA proceedings are criminal proceedings or not is slightly nuanced, because we're really asking whether the POCA proceedings are civil enforcement, which I say, because the appointment of the receiver and getting declarations to take gifts to third parties they are properly to be understood as a form of civil enforcement mechanism, which is the distinction that was drawn in the case of Lloyd that my Lord the Master of the Rolls made the point good.
Mr. Cohen, in this case, in the order that was made, there was an order made pursuant to section 72(7. And maybe you say that the provisions of section 72(7 are not relevant, but to the discussion we're having now, but perhaps you could just briefly address that section.
Of course, my lady. If the court could look behind tab 3 again, so we're still looking at the Criminal Justice Act, and just to be clear to my Lord Master Rolls, I'm now going to refer to the page number of the whole bundle, and turns to page 57.
Thank you. Yes.
Section 81 deals with what it is the receiver is to do, having obtained the money from the defendant and or recovered from third parties' tainted gifts. 81(1) provides that the enforcement of a charge does not in any way undermine, or should not undermine, what it is the receiver does with sums. And at the bottom of 81(1) we see the words that must be applied on the defendant's behalf towards the satisfaction of the confiscation order. And 81(3) deals with what it is that is going to happen when the receiver has paid the sums to court. So 81(3), the receiver is to pay the sums to court. The receipt of any sum by a Justice Chief Executive on account of an amount payable under a confiscation order shall reduce the amount so payable, but the Justice Chief Clerk shall apply the money received for purposes specified in the section and in the order so specified. So the receiver brings in the defendant's assets, then pays it to the Justice Chief Clerk. There is then a reduction in the amount owed in the confiscation order akin to that which has been paid in. And the 81(4), we then deal with the waterfall of expenses before we come to the compensation order, which my Lady the President of the Intervention Division has referred to. 81(4), we first pay any insolvency practitioner who has been appointed. This is out of the proceeds. Page 81(5), we then pay the receiver's remuneration and expenses. And I pause there for a moment because this is an important point. A key part to the prosecutor's case is that the prosecutor should be able to obtain funds from central funds because enforcement is a form of public good. And yet I say that that point is undermined by the fact that statute expressly directs that the receiver's costs are to be paid out of property. So it's not as if the entirety of the enforcement proceedings are ones that are going to be paid by the state, even on the prosecutor's case, because the receiver's funds are to be paid out of the realisable property. And then we come to 81(6). 81(6) deals with reimbursement under section 88(2), which I'll come to. But section 88(2) This deals with the occasion of where a receiver has incurred costs and sums haven't been realised and the prosecutor is to pay. And then we come to subparagraph 7. The Chief Justice's part shall finally pay any compensation directed to be paid out of any sums recovered under the confiscation order under section 72(7), and that's the point at which we dovetail to my Lady President of the Bench Division's point, which is the order itself, which provides that the compensation is to be paid out of the confiscation monies itself. Now, if one is to stand back and think about what it is that happens in reality, if there is no compensation payment made, or if sums recovered already satisfy the compensation order, the private prosecutor is not going to continue with enforcement. There is no benefit to the private prosecutor. And what payment of confiscation order means is it is simply a write-down on the statutory debt. It is a reduction on the statutory debt which the defendant wrongdoer is to pay. So the proposition that enforcement inures for the benefit of the state is, in my submission, simply incorrect. The state only obtains benefit in circumstances where there is money beyond the compensation order owed by the confiscation.
The provisions of subsection 8 provide that it's to be treated, the balance is to be treated as if it were a fine.
You're absolutely right. What one is considering here is the motivation of the prosecutor to continue with enforcement proceedings after the compensation order has been satisfied. And of course, at that stage,
well, that rather assumes a rather discrete way of proceeding, as it were, sum by sum. It's not the real life of proceedings, which, as it were, gather in all the information about the financial position of and the assets of a wrongdoer, and then value them.
I agree, my lady, that it works on the assumption that what one is doing is paying off stage by stage, but it's not difficult to conceive of a scenario where assets are being collected, and again, here is an illustration of where the difference between the confiscation order and the compensation order is some 2 million. There could well be an asset which is in a third-party hands or is in the defendant's hand, which is difficult to recover or has been time-consuming or isn't going to be recovered to a point in the future. If one assumes that the compensation order has been satisfied at that stage, the prosecutor is going to go no further, for the simple reason that there is no benefit to the prosecutor in doing so if the compensation order has been paid. So that, my lady, is where section 72(7) fits into this analysis. And again, 72(7), which is at this is bundle pagination 33. Section 72(7) again just deals with that interplay between compensation and confiscation, of course. And again, just provides the basic proposition that the compensation order is going to come first.
But the fundamental point remains is that, be it compensation or be it confiscation, either way, the public interest is satisfied because you are depriving the crook of the fruits of his crime.
The reason why I disagree in part is because whilst that is true for receivership over the defendant's assets, it is not true in respect of tainted gifts proceedings. And the reason why that is a gift pursuant to section 74 simply is a transfer of property which has taken place after the offence itself. that is section 74. Section 74, 10 and 12. That's on page 41 of the authorities bundle itself. And at section 74.10 of page 41 of the full bundle, gift proceedings simply refer to a gift made after the commission of the offence. As, and I will touch upon this because I think it is of great relevance, as the tainted gift proceedings before Mrs. Justice Jefford were an example of, the gift does not need to be a proceed of the crime, which is why in my skeleton argument I posit the situation where you've got a defendant who is liable to a confiscation order, then inherits money, and then gives it away to a third party. That money given to the third party could form part and parcel of the tainted gift proceedings. But the reason why I say that tainted gift proceedings are not a public benefit and do not have the effect of taking proceedings away from the defendant is because to be a gift, both the legal and the beneficial interest in the subject matter of the gift must have passed. So by that point, the defendant has already deprived him or herself of the subject matter of the gift. And we can see from...
I could see why you might look upon that as a property lawyer, but from the criminal perspective, it's to prevent the distribution of largesse as a means of evading the reach of the law. I mean, that's what it's about.
Well,
and you know, you're providing flats, houses, cars, etc., for the benefit of your family, and you're still. It may not be exactly the fruits of the poison tree, but it's not very far off it.
Well, my lady, perhaps if we can turn to actually the nature of the proceedings that were taken against the third party in this case as illustrative of a form of tainted gift proceedings, it'll make my point good, although I certainly don't desist from that which you've just said. At page 72 of the supplemental bundle.
72.
Page 72 of the supplemental bundle. The trial, the costs for which the prosecutor seeks from central funds, both those and those that he was ordered to pay. Paragraph 4 of page 73 provides that the subject matter is 7 transfers of money made by the defendant to his former wife. And we can see the second sentence: the purpose of the application is to have these monies declared as gifts bought by the Act and to open up the prospect of receiving may be empowered to enforce the confiscation order by recovering these gifts from the assets of the third party. Paragraph 14 over the page provides that the 7 transfers of money had nothing to do with the fraud perpetrated upon the prosecutor. That's paragraph 14. It was simply funds that he obtained through the settlement of another action, albeit that paragraph 14 does, I think, make the point that there was tax avoidance, but it certainly wasn't tainted in any way by the nature of the transactions between the prosecutor and the defendant. The next material paragraph is what Mrs. Justice Jefford concluded was a gift. And at paragraph 76, Mrs. Justice Jefford, 76, provides that for there to have been a gift, there must have been the effective transfer of the legal and beneficial interest. So these were sums that had nothing to do with the underlying offence, that had then been paid over to the defendant's wife, and to constitute a gift, the legal and beneficial interest had had to pass. And actually, as a matter of fact, Mrs. Justice Jefford concluded in paragraph 86 that the beneficial interest never did pass, so it did not comprise gifts. what happened is these funds were paid into the third party's account, but the third party only ever had legal title to them, so they did not comprise gifts. And then we see over the page at paragraph 90 is Mrs. Justice Jefford's alternative conclusion in the event that they had been gifts. And if we read paragraph 90, she says she wouldn't, in any event, have exercised her discretion to make an order that Miss Jiwala, the third party, pay the sums, not least because those sums had already been dissipated and that her only asset is the share of the flat. So far as the proposition goes that depriving the defendant of his assets is something that has public benefit, I must accept that it does. However, the receivership isn't just depriving the defendant of the fruits of the crime, it is obtaining assets to satisfy the confiscation order. But there is also a distinction to be drawn between the application for the receivership appointment and the gift application, the declaration of gift within it. Again, if we could go to the order of Mr. Justice Spencer, page 58 of that same bundle. Paragraph 1 is the appointment of the receiver. And that's page 58. Over the page at 59, at the top, we see...
Hang on. Tab 7?
I don't have tabs in mine, unfortunately. I can only give you the page number, which is 58 of the supplemental.
Right, it's 58. Okay, thank you. Yes.
Paragraph 1 on 58 appoints the receiver over the assets of the defendant to enforce the confiscation. Over the page at the top of 59, numbered 1 to 7, is we see all of the parties to this claim. And again, this was commenced as a Part A claim in the High Court Queen's Bench Division and sought only the appointment of the receiver and the declaration of gifts. And if one looks at the parties numbered 1 to 7, number 1 is the defendant, and number 2 to number 7 are parties alleged to have been in receipt of gifts. And I reiterate that those gifts do not have to be proceeds of crime. The order itself provides at paragraph 3 on page 60 for exclusive powers to be granted to the receiver. You see at 3.1 possession, 3.2 discharge. And it goes on to more substantive powers at 3.9, 3.10 and 3.11. And what is significant is that in 3.10, the prosecutor has decided to exclude from the receiver's powers the power to institute gift proceedings on the part of the receiver. And I suspect that part of the reason for that is because the receiver's costs are paid out of the defendant's assets as realised and cannot be recovered from central funds. And we see that stated in no uncertain terms at paragraph 6 on page 62.
I don't know, maybe me, Mr. Kane, this seems an awfully long way away from the issue which was supposed to be decided about the interpretation of these words in section 17.1a.
I understand, my lord. The point that I make here is that if the receiver has been given the statutory power to undertake gift proceedings, then the costs cannot be sought out of central funds.
Well, you've made that point already.
I'm grateful. And what one sees is the third-party claims on page 63. And what happened with those third-party claims on page 63 is that a number of them settled by way of consent, and consent orders were entered into by the prosecutor and the third party, providing that funds be paid out of central government. We see that in the final two orders at the back of the supplemental bundle. Well, the only point I make there is that if it is right that section 17 has effect in civil enforcement proceedings, irrespective of the court in which they take place, then in my submission, one ends up in the invidious position where consent orders have to be policed, because as is shown here, prosecutors and third parties have entered into consent orders providing that the third party bears no costs and the prosecutor's costs be paid out of central funds. That is a consequence of this appeal being allowed. The two orders I hope at the back of
Excuse me, does not the court has residual oversight? It has the discretion to make an order, and it will only be so where reasonable and proper.
My Lord, I don't defer from that at all. It is, in my submission, of note that in the substantive proceedings in issue here, the prosecutor and the defendant, prosecutor and third party, entered into consent orders providing that prosecutor's costs be paid out of central funds, and those consent orders were sealed and stamped. I can't comment on the degree of judicial oversight, but I do regard that as being a point of relevance.
Well, I missed this point. You're saying here the prosecutor and is it the defendant or the third party agreed that the receiver's costs should be paid out of central funds. Have I got that right?
No, my Lord. The prosecutor and two of the third parties agreed that the prosecutor's costs of pursuing those third parties be paid out of central funds through the mechanism of a consent order.
And what's the prosecutor and two of the third parties agreed that the prosecutor's costs, is that right, should be paid out of central funds? So whose costs should be paid out of central funds?
The prosecutor's costs of pursuing those third parties, and they did so by way of a consent order, which was sealed by the court.
Hang on. Prosecutor's costs of pursuing the third parties should be paid out. And were they successful in those proceedings or not, in recovering those assets or not?
The consent orders, and again, I hope they're at the back of your supplement.
No, but just tell them. I don't need to see them. I just need to understand what's being said here. You're placing some reliance, the relevance of which I don't see at the moment because it's my fault. But that the prosecutor and two of the three third parties agreed that the prosecutor's costs should be paid out of central funds. And I mean, these third parties, two of the third parties, are they one of the third parties we're concerned with, or somebody else?
They are not the third party that we are concerned.
So these are other ones. Were they successful in recovering from those three third parties?
One third party agreed to pay £100,000, and the other third party agreed to pay £35,000.
Right. Now, what, just in your own language, what is the relevance of this point to the Section 17 point?
The relevance is if this appeal succeeds,
Yes.
you have multi-party litigation going to enforcement. In my submission, it is simply wrong for parties to be able to agree that prosecutors' costs should be paid out of central funds. Now, of course, my Lord Justice Cleary said, well, you can just police that. I agree, but it strikes me as being an unusual position whereby every consent order needs to be read in enforcement proceedings to ensure that prosecutor and third parties haven't simply agreed that central funds will fit the bill.
Look, the obligation in Section 17 is for the court to make an order. And it's true to say that the parties may invite the court to make an order, but it must be subject to the court's oversight, because that's provided for by the terms of Section 17. And any order which is made without drawing the court's attention to that would be liable to be set aside. I mean, I think you are, as it were, without saying so expressly, raising the prospect of untoward proceedings being brought and agreements being made. But the terms of section 71 expressly require or give the court discretion as to whether to make such an order or not.
I quite agree, my lady. But as these consent orders show, what happens is that, and again, I'm not suggesting there's any nefarious intent, and it might be that I then divide a sheep in wolf's clothing. But if this practice were to continue and consent orders were to be sealed without a degree of forensic judicial oversight, then my client is going to be forced to make applications to set them aside. That's really the point I make here. But it is simply illustrative of what takes place when one looks at civil enforcement proceedings through the prism of section 17. That's really the point I make. I don't intend for it to go any further. It is a consequence were you to find in favour of this appeal.
Right, thank you.
My Lord, I'm grateful. I will, if I may, move.
Well, now can we just keep an eye on the time? We've got to give a short right of reply, which I would suggest should be 15 minutes, which leaves you about half an hour.
I'm grateful. I'm now just going to touch upon a number of the cases which I submit illustrative of why it is that this appeal should not be allowed. The first is the government of the USA behind tab 12, which I know that we've touched on. Again, simply invite the court to read from paragraph 20. Again, in the context of the Criminal Justice Act, it provides in no uncertain terms that one is dealing with the civil jurisdiction. The next case I'd like to refer to is that behind tab 19. Tab 19 is a restraint order sought by the CPS, and the material parts really start at paragraph 17. There's an appeal from the restraint order, and there was an argument consequent to the removal of the restraint order as to the costs. And we see at paragraph 17, again, the reiteration that we're dealing with civil proceedings, not criminal proceedings, and that the civil procedure rules and not the criminal costs rules govern the matter. Again, simply making good the proposition that when one is dealing under the CJA, it's part 44, which ultimately determines where the incidence of cost lies. The next, if I may, is behind tab 17. This is the Court of Appeal in Larkfield. And it's at paragraph 31.
So it's, tab 17.
Tab 17, paragraph 31.
My 17 is Revenue and Customs against May.
Indeed, sorry, forgive me. It otherwise goes by the name of Larkfield.
Sorry, which paragraph?
Paragraph 31, please.
Oh, I see. I said something in this.
Indeed.
Right.
And what paragraph 31 is addressing is that when we're dealing with enforcement proceedings in terms of, on this particular case, it was the extent of the beneficial interest owned by a third party as against that of the defendant. It's being dealt with simply by ordinary propositions of property law in the civil jurisdiction, save for where the 1988 Act provides otherwise. So the position so far as the Criminal Justice Act is concerned is that there can be and there is no dispute that the proceedings before Mrs. Justice Jefford were civil proceedings, point one. Point two is there is no dispute that Mrs. Justice Jefford was to apply the civil procedure rules, which is what she did. As a proposition, I submit that there is a deliberate distinction between the criminal jurisdiction and the civil jurisdiction. And we see that from the case of Norris. And I equally make the point that Steele 4 provides that one needs to see clear, express wording before determining that sums can be paid out of central funds. And in those circumstances, I submit that Section 17 had no application so far as the proceedings before Mrs. Justice Jefford were concerned. And there is support for that within the Prosecution of Offences Act itself. Behind tab 2 of the authorities, tab 2 and I'm referring to the bundle pagination at the bottom, page 12. At the top, we see it's entitled Defence, Prosecution of Third-Party Costs in Criminal Cases. And if we would, you'd be so kind as to turn back a page to page 11, that's bottom, the numbers at the bottom, we see at the top, Section 6, the Prosecution of Offences Act. Now, Section 6, in effect, codifies the pre-existing common law right to bring criminal proceedings or to conduct criminal proceedings. That is what it provides in Section 6.1. So if we were to continue to analyse this as we must under the Criminal Justice Act, it must be correct that by the point at which the claim was issued in the High Court, in the QBD, that the prosecutor's right to do so did not derive from Section 6, because that is simply limited to criminal proceedings or conducting any criminal proceedings. So the point at which the prosecutor issued the claim against the defendant and all the third parties, the prosecutor was doing so not under Section 6, and I submit that it is significant that Section 6 and Section 17 exist under the same statute, but was doing so pursuant to the specific power in Section 80 of the Criminal Justice Act. And it is section 80 of the Criminal Justice Act which directs that the enforcement proceedings have to be started in the High Court. That's page 56 at the bottom of the bundle, my lord. That's section 80. And the application is to be made by the prosecutor. Again, often it's made by the CPS, but it'll be made by the private prosecutor where it needs to be. So at this stage of our narrative, the prosecutor, when starting the Part 8 claim, is doing it pursuant to a totally different jurisdiction from that which he had previously operated under when at all stages up to the confiscation order. So we dovetailed from section 6 as providing the prosecutor with standing to section 80 of the Criminal Justice Act as providing the prosecutor with standing. And it's at that stage that one ends up faced with, in my submission, insuperable hurdles so far as the prosecutor is concerned, because section 80 and the cases I've taken this court to provide in no uncertain terms that the matter that was addressed by Mrs. Justice Jefford was done so in the civil jurisdiction governed by the CPR in circumstances where section 17 itself is under a heading which provides for prosecutors' costs in criminal cases. And the government of the USA in Montgomery case makes no bones about the fact that enforcement proceedings under the CJA cannot be a criminal case. Indeed, if it were a criminal case, this appeal could never be heard. And that, I think, brings us back to a point that I know my Lord Justice David wanted to address, which is, well, what happens now that enforcement proceedings, and by enforcement I'm talking about civil enforcement, I'm not talking about criminal enforcement, I want to make that distinction clear. Criminal enforcement is where, as in the case of Lloyd at tab 15, criminal enforcement is where you issue a warrant to commit the claimant to custody. That is criminal enforcement. And of course, we know that the Crown Court proceedings continue as such time as the confiscation was satisfied. So if you go to the Crown Court to issue a warrant, to issue a warrant to commit the defendant to custody, you are going back to the criminal proceedings that arose from the Crown Court. And that's why His Honour Judge Horne's order provides as it does. But where you are addressing civil enforcement, and the government of the United States and Montgomery make clear in paragraph 12 that there is absolutely no meaningful distinction between a receivership which is obtained pursuant to section 80 and one which is conventionally obtained in the civil jurisdiction. And equally, as we know from my Lord, the Master of the Rolls' judgment in what I misdescribed as the Larkfield case, that I should properly call that which is behind tab 17, Revenue and Customs in May, we are dealing with conventional property law issues so far as gift proceedings are concerned. And that is why when we were dealing with the settlement monies that were paid over before Mrs. Justice Jefford, the question was whether the legal and beneficial interests passed. So I submit that if one takes Pocker out of the equation, which isn't directly on point given that we're ultimately addressing only the Criminal Justice Act, there can be no conceivable objection to the construction that I put before this court, which is the words "in respect of an indictable offence" are to be understood as coexisting with the right to prosecute under section 6 and therefore restricted only to criminal proceedings. and again, I'm putting POCA to one side, the reserve position, which I've taken out of order, but my Lord the Master of the Rolls entirely identified, is that even if that weren't correct, that case of Taylor and Westminster provides an additional argument for why it is that civil enforcement proceedings are not in respect of an indictable offence. And it's the distinction that is drawn there between ultimately when one is dealing with receivership over a statutory debt, ultimately one is talking about remedies in respect of sums owed, rather than the indictable offence itself, which again brings us back to the wording in section 17, which I submit was chosen with care. It does not say in respect of the indictable offence, and it does not say as a result of an indictable offence. The question is simply looking at proceedings that took place before Mrs. Justice Jefford. So we've got our new Part A claim in the High Court. Were they in respect of an indictable offence? And I say the answer to that is no. I will address the position so far as POCA is concerned, because my Lord Justice Davis and I had an interchange before where he, in effect, put me to my election as to whether one is dealing with POCA, which now takes place in the Crown Court, those should probably be understood as criminal proceedings and civil proceedings. And my answer was, it rather depends on whether one identifies that by virtue of the court which is giving the determination or the subject matter that the court is addressing. And the reason why I say that there is no change of position given at POCA, and I derive support from that for the fact that new Criminal Procedure Rule 33 deliberately incorporates Civil Procedure Rule 44 propositions as to costs, is because the appointment of a receiver and tainted gift proceedings are a civil enforcement remedy, not a criminal enforcement remedy. And that distinction is made in stark terms in the case of Lloyd behind tab 15. In that case, Lord Dyson goes to pains at paragraph 24, which my Lord the Master of Rolls referred my learned friend to draw a distinction between civil methods of enforcement and criminal methods of enforcement. It's behind tab 16 and it's paragraph 24, which is Authorities Bundle Reference 351.
Sorry, which tab was that?
Forgive me, tab 15.
Thank you.
And if one looks at the front page behind tab 15, the head note provides that it was dealing with an application to the Magistrates' Court for a warrant to commit the claimant to custody for non-satisfaction of a confiscation order. And at paragraph 24, a very deliberate distinction is drawn between criminal methods of enforcement, like the issue of a warrant, and civil methods of enforcement. So when I answered my Lord Justice's question about the fact that POCA brings it under Crown Court with the answer that ultimately it's not the nature of the court, it's the nature of the remedy that determines the outcome. And I say this is the Crown Court has now been given, as a consequence of POCA, the ability to make civil remedies, and the appointment of a receiver, as the government of the USA and Montgomery states in no uncertain terms, is a civil remedy, irrespective of the court from which it derives. There is harmony between the Civil Justice Act and POCA, which is simply that the Crown Court is dealing with receivership and restraint, which should properly be understood as being in the nature of the civil remedy. And there is support for that in the criminal procedure rules themselves. As I have taken this court to, Part 33 incorporates Part 44 purely for restraint and receivership proceedings. It goes no further than that. What we now have is a bespoke costs regime in the Crown Court for restraint and receivership proceedings. And if one goes to the authorities bundle and looks at the authorities
Well, I
number,
think it goes. Look, I may be wrong about this. I thought you were going further than that. I mean, it's an inevitable consequence of what you're submitting, but you're not saying it expressly now, which is that there is no provision anywhere, whether it's under Regulation 33 or anywhere else in the criminal proceedings rules or regulations, or in POC itself, which provides for payment out of central funds.
for enforcement
For
proceedings.
enforcement.
Indeed. If I can just take you to...
But I mean, that's quite, I mean, you're kind of skating over that. That's quite an important point for you, isn't it? Because the position would then be that rather than the discrepancy between, as it were, if the appellant is right, being able to recover out of central funds under the 1988 Act, but not under POCA, that rather than the position being, it would be very odd, as the appellant says, that you can't recover under central funds under the 1988 Act, but you can under POCA. You would say, but it would be even more odd. I think you would say, be even more odd if you can recover out of central funds for the 1988 Act, but not under POCA.
But indeed, my lord, I say that there is an equivalence between the two, such that the position hasn't changed.
Now, I understand that. I'm just pointing out, the way each side is putting, as it were, how odd it would be. But one assumes, I'm sorry, until you made your submissions, I had proceeded blithely on the assumption that it was common ground that you could recover out of central funds for enforcement under POCA.
Indeed, my lord. My learned friend made extensive submissions on it this morning, which not entirely reflected, I think, in the way that the appeal had been set up to date. But I'm pleased to have given the opportunity to make it clear that the position under POCA, and there is reference in my skeleton argument to what I say about this paragraph 27. I make the point that the position under POCA is no different under the Criminal Justice Act. But you're quite right, my lord, of course, to make that point more express. What I will do now, just for 5 short minutes, is go to various supporting documents.
Don't you want to go to ground 2? Or you're not going to deal with ground 2?
I am going to deal with ground 2, but like my learned friend, I'm going to deal with it very briefly. I'm working the assumption that I'm going to be able to trespass on the court's time for another 15 minutes, so I hope you'll grant me that indulgence.
Well, you're definitely going to have to, well, I'm not sure. I think you're going to have to stop at 5 past.
Of course, my lord, I'm not going to push any further.
My lord, if it assists, I'm likely to be very brief.
Thank you very much. That's very helpful. Carry on.
I'm very good, Dr. Christian. I will then just deal with other relevant documentation insofar as it bears on the issue. At page 201.
This is under supplemental bundle or the authorities bundle? Or what?
This is authorities bundle, and that is page numbering at the bottom.
Yes.
What we've seen is that Criminal Practice Direction 33 provides for bespoke costs rules for restraint and receivership proceedings. We've got our bespoke rules. What we see at page 201 are the Part 45 general rules.
Yes.
And the particular provisions I'd like to take the court to, if one goes to page 206, we've got costs out of central funds.
Yes, thank you.
And it's 45.43a provides that an application has got to be made. At 45.45b, we've got an illustration of when the court is going to decline to make an order. And over the page, at page 208, in the notes, under subparagraph B, provides that for a prosecutor, costs are recoverable out of central funds in proceedings in respect of an offence that must or may be tried in the Crown Court. So that is the...
Where are you from? I've lost you.
Forgive me, my lady, it's the top of page 208, subparagraph B.
Yeah.
Yes.
So if one goes back to page 207, it says an order for the payment of costs out of central funds can be made, subparagraph A, for a defendant, and subparagraph B is for a prosecutor, and so far as the practice directions are concerned, in respect of an indictable offence means in respect of an offence that must or may be tried in the Crown Court.
Right. You've lost me. I had you 45.4. Then I had 3.
And it was A, and then it was 5B at the top of page 2.
Then I had 5B.
And if, my lord, you look further down, you'll see the words in italics. It says an order for payment of costs out of central funds can be made.
What are these italics?
These are the notes.
These are notes.
Notes.
So what status do they have?
Well, the same status as notes to the White Book would have so far as civil procedure rules are concerned.
Well, they have no status.
Well, there's no distinction between my learned friend and myself. That, as he puts it, when one is looking at practice directions, these are at best weak tools of interpretation. But I think they are instructive as to how it is that people do proceed so far as these matters have been considered up to the present day. And it is significant that in respect of the indictable offence, so far as the notes are concerned, it's dealing expressly with the offence itself in the Crown Court, not dealing with enforcement proceedings, dealing with satisfaction and confiscation.
Yes, thank you.
And I'm grateful. The next point, and again, it's going to be equally brief, is at tab 23. The document that I've just taken you to is the Criminal Procedure Rule. This document is the practice direction.
So this is tab
23.
Yes, thank you.
And it's the second sentence under paragraph 1.2.4. That's bundle page 457.
Yes.
And what one sees is we've got the National Taxing Team for the Magistrates Court for the Crown Court and the Registrar for Criminal Appeals for the Court of Appeal. And of course, what we don't have is anything for the High Court, which itself is just supportive that under the Criminal Justice Act, proceedings in the High Court would not be ones which would anticipate or be understood as giving rise to a right to recover out of central funds. I don't think the proposition is any higher than that. And equally, over the page at the top of bundle.
So your point is that 1.2.4 doesn't refer to the High Court, is that the point?
Exactly that. And again, I'm going to come on to the 1986 regulations, but one of the important facts is that section 17 provides that regulations will be made that will determine how costs can be assessed. And the 1986 regulations have no mechanism for assessing costs from a single judge in the QPD.
Well, that if you look at 2.3 on page 462, there's a reference without any identification of mechanism of the High Court.
Yes, but the point there, my lady, is you do have a mechanism for a divisional court sitting in the QPD. That's going to be dealing really with appeals by way of case stated, but there is no mechanism for a single judge. That's the point that I make from this practice direction, which is supported by the 1986 regulations.
Well, I'm happy to look at this, but for my part, I think it applies to both counsel. Looking at a practice direction made in 2015 to cast light on the proper interpretation of an act made in 1988 or earlier does not really seem to me to be very helpful.
I entirely understand, my Lord. I'm going to move then on to the 1986 regulations, which I think are infinitely more pertinent. First, if I may, and I'm entering into the final straight, so to speak, and I'm going to deal with issue 2 at the same time. If we were to go back to the Prosecution of Offences Act, this is behind tab 2, and it's page 17 of the bundle, page 17 of the authorities bundle. What one sees under this now very well-travelled provision is that paragraph 17.1 provides for the principle, and the mechanism is provided at paragraph 2c over the page. Paragraph 2c, so paragraph 2b provides that the court can fix the amount if the prosecutor agrees, or subsection 2a applies. So that's where the court decides to make a reduction. And in the vast majority of cases, 2c will be the one that's engaged and was engaged in this case, which provides that 2cb, the amount must be fixed by means of a determination made on behalf of the court in accordance with procedures specified in regulations made by the Lord Chancellor. So now, my lords, my lady, those regulations are the 1986 regulations, which appear behind tab 6. And behind tab 6 at authorities bundle
Sorry,
page.
can you just remind me, when was section 17(2) capital C, when was that introduced?
It was, I will make this point good by way of email if needs be, but it was originally there. But the reason why one sees it in square brackets is there's been what I describe as a degree of rejigging within the statute. But there has always been a mechanism for regulations to provide for the means of determination.
Well, speaking for myself, it might be quite helpful to be sent a copy of the Act in its original form.
I gladly do that, and I'll do that straight afterwards. But if one can just assume for these purposes that there has always been a mechanism and regulations provided thereunder for the determination of the quantum of costs where that quantum is not ordered by the court. If one could just take that as writ at present, and I will arrange for the original Act to be sent to your clerks the moment the hearing finishes, we can then turn to tab 6, which is the 1986 regulations themselves. And I'm going to ask my lords, my lady, to turn to page 136 of the bundle. Again, I'm afraid I'm using authorities bundle numbers, because absent those numbers, that there is no means of identifying without clicking through. And you will see there regulation 4. The two lines under regulation 4 provide that this part of these regulations applies to costs payable out of central funds in pursuant to an order made under or by virtue of part 2 of the Act in this part of the regulations. And then it says appropriate authority has the meaning assigned to it by regulation 5. And the costs order is defined as being an order made under or by virtue of part 2 of the Act for the payment of costs out of central funds. And critically, for the purposes of the second issue, expenses is out-of-pockets expenses, travelling expenses, and subsistence allowance at the top of the page. And then, if you be so kind to turn over leaf to Regulation 5, which is at page 139. Regulation 5.1 provides that costs shall be determined by the appropriate authority in accordance with these regulations. And then Regulation 5.2, subject to paragraph 3, the appropriate authority shall be A, the Registrar of Criminal Appeals in the case proceeding in the Court of Appeal, B, the Master of the Crown Office in the case of proceedings in a Divisional Court of the Queen's Bench Division, and C, we've got proceedings in the Crown Court. Now, the point here is if one dovetails back to section 17, what it provides is costs in respect of an indictable offence, or for a summary offence where there is a divisional court of the QBD or Supreme Court's involved. Regulation 5 provides no mechanism for assessing costs where there is a single judge sitting in the QBD. Again, Section 17 expressly provides for divisional court in the Supreme Court with respect to a summary offence. That's going to be an appeal by way of case stated. That's Section 17. And we dovetail that with Regulation 5, which again provides for the mechanism of assessment where the proceedings are in the divisional court of the Queen's Bench Division. It is silent on what happens rather, when you put a single judge of QBD. And that's why it is that my learned friend resorts to the administrative court guide, which provides that you then adjourn the matter of costs and sit in divisional court as his solution. In my submission, that's an inelegant solution and goes against the grain of Regulation 5, which does not anticipate that a single judge in the QBD is going to be making an order for costs out of central funds, simply because there's no mechanism for finding out under the regulation, 1986 regulations, how much that is going to be. On page 143, and I'm now just dovetailing to 3 very short points on what the word expenses in section 17 means. What my learned friend says is it's legal costs, whether those legal costs are incurred by the prosecutor or incurred by him as a consequence of a court order in respect of legal costs from other third parties. And you, my lords, my lady, were taken to page 143, which is Regulation 7. And what was said by my learned friend is that Regulation 7.1 means that legal costs can be recovered irrespective of whether they're actually incurred by the prosecutor or simply ordered that the prosecutor pay to a third party. And I say that that is just measurably wrong. Section 7.1 deals with documents submitted by an applicant. So documents submitted by the prosecutor, and then one is allowing costs in respect of work and disbursements, legal costs. And Regulation 7.5 provides that those legal costs that be reasonably sufficient to compensate the applicant for any expenses properly incurred by him in the proceedings. There is nothing in Regulation 7 that suggests that legal costs can include costs the prosecutor is ordered to pay a third party. And in my submission, that proposition is simply wrong. The next regulation, as I come to the end of this, I have one very brief authority to make mention of this, but I'm now also aware that I'm on borrowed time, given my legal friend's kind indication. In addition to legal costs incurred by the prosecutor, the only other expenses are set out at Regulation 23, which is on page 173. And Regulation 23 on page 173.
What is the relationship between Regulation 5, which you took us to, which deals with, Regulation 5, which deals with, I've got that wrong, I'm so sorry, the expenses one.
Regulation 7.
It was Regulation 7, I've got Regulation 5 for some reason. No, you're just turning it to Regulation 5. Where it expressed what the expenses were.
The definition of expenses is in Regulation 4.
Oh, it's 4, I'm so sorry, I thought it was in Regulation 5.
Not to my daughter. What I think properly construed this set of regulations provides is Regulation 7 is dealing with legal costs. And Regulation 7 deals with work done and disbursements.
Sorry, what is dealing with legal costs? Regulation
7 deals with legal costs which have been incurred by the prosecutor.
Right.
And the only items of cost in addition to that which can be recovered are set out in Regulation 23, which is consistent with the definition of expenses that my Lord just made a reference to, which is out-of-pocket expenses, travelling expenses and subsistence allowance.
Which page is that?
Regulation 23 is on page 173.
Right, well, when you took us to a definition of expenses.
That's on page 137.
No, I understand that, but where is it in these regulations that there's a reference to expenses?
It's in Regulation 23, deals with the definition of expenses. Expenses is out-of-pocket expenses, travelling expenses, subsistence allowance. Regulation 23 then makes express provision for those, and it's Regulation 24 that then deals with travelling expenses, and Regulation 18 that deals with subsistence allowance.
Right. 23, a person whose favour an order is made under 16, 17 or 19 of the Act may be allowed the same subsistence allowance and travelling expenses as if he attended as a witness, right? Right, so that's under 17, section 17. Right, then you say we go over the page to travelling expenses, which have been referred to in 23.
Exactly, and then Regulation 18 deals with...
Regulation, so we're going back now.
Indeed, forgive me, it does. This statute is painful to work through. Regulation 18 then deals with subsistence allowance.
Where does it say that?
18b.
18.1b, is it?
18.1b, a subsistence allowance not exceeding the relevant amount. So Regulation 23 says they can be recovered notwithstanding that the prosecutor is not a witness, and then Regulation 18 gives you the ability.
Right. So, but you're saying none of those are relevant to an adverse order for costs.
It's exactly that.
But you say that if it's to be covered, if it's to be covered anywhere, it would have to be under Regulation 7. You accept that so it all turns on Regulation 7.
I entirely accept that, my Lord. Regulation 7 deals with legal costs, and the question for the court is whether, on its proper construction, that can include legal costs a party is ordered to pay rather than legal costs.
Can I just read that, because it's going quite fast? Can I just read 7? So you can allow costs in respect of such work as appears to be actually and reasonably done, actually and reasonably occurred. Take into account all relevant circumstances. If there are any doubts, you resolve them against the applicant. Then you allow such legal costs as it considers reasonably sufficient to compensate the applicant for any expenses properly incurred by him in the proceedings. So how does that marry in with everything else? So it's such legal costs as are sufficient to compensate for any expenses, but you've drawn our attention to what expenses mean. So how do we deal with that?
On its proper construction, and I don't try and shy away from the solicitors drafting these regulations, I submit that what it's providing is that the prosecutor can recover its legal costs and those subsistence expenses and travel expenses, and nothing beyond that. Now, the reason why Regulation 7.5 uses those words is because it is borrowed directly from Section 17 of the Prosecution of Offences Act.
Okay. Thank you.
Well, the final 2 points which go to this issue are as follows. I'll keep them, again, very brief. Behind tab 21 is the case of Virgin Media and Zynga, which addresses Section 17 costs order made in confiscation proceedings. So not enforcement proceedings, but confiscation proceedings. And what one sees at the top of the page, and I'm looking at bundle numbering, rather the bottom of page 430, this is paragraph 19. Paragraph 18 provides that there's little case law on Section 17 of the 85 Act. 18 also provides that one can draw a direct equivalence between Section 17 and Section 6. This is paragraph 18 on page 430. And then paragraph 19 sets out the twofold test for legal costs. And all of this is redolent of the prosecutor instructing solicitors. It is not redolent of the prosecutor having to argue on behalf of the third party that their actions in identifying the relevant solicitors were correct.
Yes.
And then over the page at subparagraph 21(1), we get a further exposition of the question that the court is to ask itself. And again, I submit that's all redolent of the prosecutor arguing for his own expenses. It would be not just unusual, but procedurally extremely difficult for the prosecutor to be advocating the quantum of recovery for a third party's costs.
But of course, this point doesn't arise at all if the appeal is dismissed.
You're absolutely right, my lord. This only
So
arises
one
if
of
you're
your
against one third.
one of your points, I suppose, is that this sort of complication we're dealing with arises out of what you submit is an improper interpretation of Section 17 in the first place.
Indeed, my lord, but it also gives rise to a point that my lord, Lord Justice Davis made, which is when the discussion was made about a disparity in the rights between the third parties, the enforcement proceedings, and the defendant to the enforcement proceedings, it was suggested that my learned friend that the prosecutor would simply recover the third party's costs and therefore there was no disparity. But of course, if the prosecutor has behaved unreasonably, the prosecutor is not going to be able to recover any costs, which means we end up in the unusual position where the worse the prosecutor behaves, the more the third party is disadvantaged, which in my submission can't possibly be right.
Yes.
My lord, the second last point deals with discretion. Discretion is a live issue. If this appeal is allowed, then the jurisdiction has been established, but the discretion has not, because the discretion hasn't been addressed by Mrs. Justice Jefford, given her conclusion on the jurisdiction. And well, as the final point, I'm just going to give you a bundle reference for. I can take you there if I wish. But the House of Lords.
I'm sorry. You've seriously overrun when you said you finished. But
I apologise.
Justice Jefford made no finding as to reasonableness or properness. Indeed, in her previous decision, she actually she'd accept that they had been proper and reasonably occurred. Surely this court cannot make its own assessment, can it?
No, I think in circumstances where the court held that a jurisdiction did exist and whether whichever limb one is engaged in, you then have the discretion as to whether a cost order should be made. And I'm not suggesting that this court makes it, but I'm...
No, we decide the jurisdiction point, and obviously if you win on ground one, you win altogether, but if you lose on this point, then surely the matter has to be remitted back. So the decision on reasonableness should be made.
I entirely agree with that, my lord. I'm not suggesting for a moment that I just didn't want to think that it was a done deal, but I'm not suggesting for a moment that this tribunal addresses the matter of discretion. Far from it. The final point...
But the point that was raised by Mr. Friston is we're dealing with a situation where the judge has already exercised her discretion were she found to be wrong second time round. Because first time round, she exercised her discretion for better or for worse in favour of the appellant. So Mr. Friston said, well, the point of law we're dealing with was she wrong in changing her mind on the ground one, and if she was wrong, then we simply go back to her previous decision.
The only point I do make on that is the degree to which her discretion is affected by arguments that she did not hear, which have now been run in relation to issues 1 and 2. That is fundamentally the point I do think.
All right, anyway, you said you go back. Right, well, you know, you have very seriously overrun now, but carry on.
I do. If I can I just want to make a page reference as much as anything else. The House of Lords notes on clauses for section 17 I don't want to put too much weight on this, my lord, because I suspect I'm on borrowed time for better time, but it's at page 119 of the supplemental bundle. And it's the bottom 6 lines of paragraph 2. Which says the prime prosecutor will be able to recover any expenses properly incurred by him in the proceedings. This will include his legal expenses and out-of-pocket expenses, not the loss of earnings. The private prosecutor will also not be able to recover any investigation expenses, for example, charges made by a private inquiry agent instructed to make inquiries before commencement of proceedings. The only proposition I take from that is that it is again totally inconsistent with the idea that prosecutors could recover the costs that they have been ordered to pay for having failed in a particular issue on litigation. It is simply not consistent with that. But again, I'm also well aware of the status that one puts on parliamentary documents, so I don't press the point any further, and unless I can help your lords and your leadership. Those are my submissions, and thank you again for allowing me the time that you have.
Thank you very much. Thank you, Mr. Cain. And Mr. Friston.
My lords, I'll be very brief. I will deal first with just 1 or 2 small matters arising out of the regulations. So I'm talking here about 1986 regulations. You've been taken to the fact that the regulations deal with a number of expenses.
Mr. Friston, you don't have your camera on.
Oh, I do apologise. Is that worked?
Yes, that's it.
Thank you very much. I was just making the point that the word expenses, as used in most of the 1986 regulations, means an entirely different, has carries an entirely different meaning to that which is used in section 17 of the Prosecution of Offences Act. In fact, they are words of expansion. I would ask the court just to bear in mind that ordinarily, when costs are payable between opposing parties, expenses of being a litigant, as opposed to the expenses of litigation, are not recoverable. But in criminal proceedings, there are words of expansion, such as in the 1986 regulations, that allow certain out-of-pocket expenses of being a litigant to be recovered. And that is why the 1986 regulations start off at Regulation 7 with saying, well, costs will be payable essentially on the standard basis, but then go on to deal with a number of other minor matters. And it's entirely wrong, in my respectful submission, to point to those regulations and say, well, they don't say anything at all about payment for adverse costs, because that is not their purpose. The reason that there's mention of expenses and various other categories of monies is generally because they are trying to, or they are creating entitlements where otherwise entitlements wouldn't be there, or because they are trying to restrict certain expenses to certain amounts. So it would be wrong to read too much into that. As I understand matters, my learned friend seems to rely on the fact that there's an absence of any provision within the criminal procedure rules, as would apply to a to enforcement proceedings under the 2002 Act to central funds. And as I understand matters, he says, well, that implies that even under the 2002 Act, a prosecutor would not be able to recover the costs of enforcement. Well, I just like to make the point that the criminal procedure rules govern criminal procedure. They do not govern funding. Costs and funding are fundamentally different in exactly the same way that you find very, very few references in the CPR or in their associated practice directions to legal aid. That's because they're dealt with elsewhere. The criminal procedure rules simply govern costs between opposing parties and the like, and the absence of any mention there of costs payable out of central funds in enforcement proceedings is not something which carries any particular significance.
Whereabouts elsewhere in your word does one find provision for it then, if it's not in the criminal procedure rules? Where do you find it?
Find provision for the determination of the amount
for the purpose of POCA. Just quickly tell us where we find it.
Sorry, I think we may be cross purposes. I am talking about making awards of awards out of central funds and their determination. And in my respectful submission, those provisions that apply to awards generally out of central funds that relates to proceedings in the Crown Court would also apply to proceedings in respect of the 2002 Act. So if the question is directed at what the Crown Court does under the 2002 Act, then that is the answer. I'm afraid I'm not.
But what is the I'm so sorry. What is the provision? What is the provision under POCA?
The provision ultimately is Section 17 of the Prosecution of Offences Act.
This is under POCA.
Sorry, no. So I think we may be across purposes.
No, the question asked by Lord Justice Davies, which I'm also interested in the answer to, is what is the provision that you say enables the Crown Court under POCA to order payment out of central funds for enforcement of confiscation orders?
My Lord, I'm afraid you cut out there, but I think the question was what is the provision in the Crown Court that allows under the 2002 Act the courts to make an award? I'm afraid I'm not able to answer that. I probably would be able to provide an answer by email shortly after this hearing, but I'm afraid I'm slightly taken by surprise by some of the points that my friend has made, and I'm not in a position to give to answer that specifically. But in general terms, I say it is the power that permits the courts to make awards of central funds generally.
Yes.
But the main thrust of my friend's submissions appears to have been that, and this relates to ground 1 more than ground 2, appears to have been that once the confiscation order has been made, regardless of whether it's under the 2002 or the 1988 Act, the character of the proceedings changes. He wasn't really able to say whether they become civil or criminal, but they change in such a way that they cease to be in respect of an indictable offence. And he went on to explain that in certain circumstances, the benefit would all be eaten up by way of confiscation or by way of compensation orders and by payments to receivers, and it becomes quasi-civil. And in those circumstances, it is only right that the court interprets Section 17 narrowly. Well, my little friend even went so far as to say that the benefit of enforcement proceedings, either under the 2002 or the 1988 Act, does not ultimately inure to the Crown. Well, in my respect for submission, that is simply wrong. If one follows through the waterfall, for example, out of Section 81 of the Criminal Justice Act 1988, you will find that at the bottom of it is the Crown.
But you took us through those provisions.
Yes, indeed. Yes. So it is certainly true to say that any insolvency practitioner will have first bite, and then compensation or payments may be made. But to suggest that that becomes in some way no longer part of the criminal process, no longer in respect of an indictable offence, is just simply wrong. And in that regard, I pray and aid the point that the President of the Queen's Bench Division made, and that is just look at the order in this case. The order in this case is redolent of it being something very much more than a mere fine, or very much more than a mere civil debt. I recognise, of course, that there may be circumstances where a prosecutor is acting solely in their own interests, primarily in their own interests. I recognise, of course, that there may be circumstances in which a prosecutor acts in a way that requires a degree of oversight. So, for example, agreeing a consent order where monies are paid, or where costs are paid out of the central funds rather than by the person who's returning a gift. But those are all matters that are not, that are dealt with by way of the court exercising its oversight and exercising its discretion. They have no bearing at all on the, in my respect for submission, on the interpretation of Section 17. Because at the other end of the scale, there will be those prosecutors, those private prosecutors, who rely very heavily on payments from central funds. People or organisations such as the RSPCA. And it would be quite extraordinary, wouldn't it, in my respectful submission, if the RSPCA, for example, were to successfully prosecute some large-scale criminal enterprise relating to the mistreatment of animals, to get a confiscation order and then suddenly fall off the edge of a cliff in terms of their funding by virtue of a narrow interpretation of Section 17. That would just defeat the point of having private prosecutors in cases where the crimes to be prosecuted are highly profitable crimes, and would defeat the point of confiscation orders generally. would make them, as Mrs. Justice Jefford said, make them toothless. And in my respectful submission, the correct interpretation of Section 17 is that, in principle, the costs of enforcement are recoverable. My Lords, unless you have any questions, those complete my submissions.
I'm very grateful to Mr. Friston for dealing with matters so succinctly. I don't know whether any other members of the bench have any questions for Mr. Friston. No.
Thank you.
So, thank you very much. Well, can I thank both counsel? This is obviously an important matter. We will consider our judgments. In the usual way, in due course, when you receive our judgment or judgments, will you please agree a form of order? Any further submissions to be in writing, unless we ask for oral submissions. Thank you all very much indeed.